The estate of Horton versus Jones, a recent Michigan case involving an electronic will. That's the subject of today's ACTEC Trust and Estate Talk.
Welcome to ACTEC Trust and Estate Talk from the American College of Trust and Estate Counsel, a professional society of peer-elected trust and estate lawyers. This series offers professionals best practice advice, insights, and commentary on subjects that affect our profession and clients. To keep up with the changing world of wealth planning, subscribe at iTunes, Apple Podcasts, Stitcher, Google Play, or other podcast sites. And now, our ACTEC fellow host with today's topic.
This is Birch Douglas, an ACTEC fellow from Richmond, Virginia. Can a person create a valid will that is not formally executed as required by state law? There are some states that have adopted a harmless error statute. There have been several cases recently worldwide on this subject as it relates to electronic writings. Here today to discuss the recent Michigan case, the estate of Horton versus Jones, is ACTEC fellow Karen Farner of Philadelphia, Pennsylvania. Karen.
Thank you, Birch. In Horton, the Michigan court dealt with Michigan's harmless error statute, which is actually based on the Uniform Probate Code, as applied to the attempted probate of an electronic writing. On appeal from the lower court's decision to admit to probate the electronic writing as the last will of the decedent, the Court of Appeals, per curiam, affirmed. What I'd like to go over are the facts, Michigan law, some of the arguments of the parties, and then the court's analysis. The facts in this case are tragic. The decedent committed suicide at the age of 21 after leaving an undated, handwritten journal entry, which stated, quote, "My final note, my farewell is on my phone. The app should be open. If not, look on Evernote." And it turns out Evernote is a software application that can store audio memoranda and web pages and emails and documents. The journal entry, which was in the decedent's handwriting, also provided an email address and a password for Evernote. The Evernote application was on the decedent's phone, and it contained a typed, not a handwritten, electronic writing, which I'm going to call writing for purposes of this discussion. It existed only in electronic form, and the decedent's name was typed at the end of the writing. Among the personal sentiments expressed in the writing were things like religious and self-deprecating comments, apologies, and requests relating to his funeral arrangements. But in addition, there was a full separate paragraph on how he wanted his property distributed. And here are some illustration of what he included. "Have my uncle go through my stuff and pick out the stuff that belonged to my dad or grandma and take it. If there's anything he doesn't want, feel free to keep it and do with it what you will. Make sure my car goes to," and it named a particular family member. And then he said, "Make sure my trust fund goes to," and he named another family member. He had a separate paragraph that he had addressed to his half-sister and stated in it that he wanted all of his money to go to her. The decedent had been subject to a conservatorship during his lifetime. After the decedent's death, his court-appointed conservator filed a petition for probate and appointment as a personal representative, nominating itself as personal representative and seeking to probate this writing, this electronic writing. The decedent's relative had also filed a petition for probate, nominating herself as personal representative and alleged intestacy. So before we can get into the arguments of the proponent of the will and the contestant of the will, this electronic will, we should know a little bit about Michigan law. First of all, the question would be who can make a will? And the second would be, what are the requirements of a will? As to who may make a will, any person who's over age 18 and has sufficient mental capacity may make a will. As to what the requirements are, a will is valid if it's in writing and signed by the testator and signed by two witnesses. And there are some exceptions to this, two of which were considered by the court. One exception has to do with a holographic will, a will that doesn't comply with the formal requirements of execution, but still may be regarded as valid as a holographic will, whether or not it's witnessed, if it is dated, and if the testator's signature and material portions of it are in the testator's own handwriting. This document that was the electronic writing clearly was not a holographic will because it didn't have a signature and there was nothing in the testator's own handwriting. But the next statute, which was an exception, is called the harmless error statute. And that, under Michigan law, says that although a document or a writing was not executed in compliance with the formalities of executing a will, it can be treated as if it was in compliance if the proponent of the document establishes by clear and convincing evidence that the decedent intended it to constitute the decedent's will. So against this backdrop, we have arguments. The contestant said that there was no clear and convincing evidence at trial, said that there was only an attempt to make a holographic will, which failed, and said that the lower court erred by recognizing this electronic writing as a will and in accepting a printed copy of the writing as into evidence. Further, the argument was no one saw the decedent type the writing, and that actually creates a question of its authenticity. The proponent had introduced into evidence the circumstances surrounding the decedent's death and the discovery of his suicide note and the contents of the writing. The handwritten journal entry was stated to be in the decedent's handwriting, and it actually directed the reader to go to the decedent's phone to locate the writing. The specifics of the writing, the court held, were very clearly intended to describe his assets and to say how those assets be distributed. Certain information about the journal and the phone, including the decedent's leaving it in his room before he left to commit suicide, were also introduced. The court agreed with the lower court's conclusion that the evidence was unrebutted, that the deceased hand wrote a note directing the reader to his cell phone with specific instructions as to how to access a document he had written electronically in anticipation of his imminent death by his own hands. So, in summary, the Court of Appeals held that the lower court did not err when it concluded that the proponent established by clear and convincing evidence that the decedent intended his electronic writing to be his will, and it agreed with the lower court that the electronic writing was properly admitted to probate. While Michigan does have a statute regarding the formalities of a will that are generally necessary for a will to be valid, Michigan also has statutory exceptions. One of these exceptions, as we discussed, is its harmless error statute. That statute treats a writing as if it had been executed in compliance with the formalities otherwise required for a will to be valid if the proponent of the writing establishes by clear and convincing evidence that the decedent intended the writing to constitute a will. It was on the basis of this statutory exception that the electronic will in this case was allowed to be probated. And that is the conclusion of the summary of the Horton case.
Well, Karen, thank you so much for this update on electronic wills.
Thank you for listening to this episode of ACTEC Trust and Estate Talk, the podcast about wealth planning matters from the American College of Trust and Estate Counsel. To find an ACTEC lawyer near you, visit actec.org. Please subscribe to this podcast and leave us a rating or a review at iTunes, Apple Podcasts, Stitcher, Google Play, or wherever you download your podcasts. Follow us on Facebook and Twitter at ACTEC Talk.